Hello and welcome to the Green Card Application through Immediate Relative Petition Self-Assessment video brought to you by ImmigrationEase.com, where affordable, professional quality immigration case preparation is made as easy as 1, 2, 3. Before we dive into the assessment, please click the pause button to read our disclaimer and then resume the video as soon as you're done. So, you're interested in applying for a green card through an immediate relative petition. Well, step 1 in the process is to find out if you qualify for the benefit in the first place. So, without further delay, let's begin the assessment. Question number 1. Is the petitioner a U.S. citizen over the age of 21? Yes, in order to file an immediate relative petition, you have to be a U.S. citizen over the age of 21. And an immediate relative petition is a petition where the beneficiary gets the benefit to apply for a green card along with the petition. So there's not really a wait time for a priority date to be current. Let's go to the next question. Question number 2. Is the beneficiary an immediate relative of the U.S. citizen petitioner as defined by immigration regulations? Immigration regulations have a very particular definition of immediate relative. Under U.S. immigration law, an immediate relative includes the following family members of U.S. citizens: spouses of U.S. citizens, unmarried children of a U.S. citizen who's under 21 at the time the petition is filed, and parents of U.S. citizens. Those are the 3 main categories. Now note, there are special rules that apply to petitions involving adopted children, adoptive parents, children born out of wedlock, stepchildren, and stepparents. And these are not accounted for in this self-assessment, and we're doing so for the sake of simplicity. So keep that in mind. Question number 3. Is the beneficiary in the United States? If the beneficiary is outside of the United States and cannot enter the United States on a dual intent visa, then it is recommended that they do not seek a visa such as a visitor visa, which is not dual intent, to enter the United States and then apply for adjustment of status. It is possible that if they do this, USCIS will consider the visa application, for the visitor visa that is, to be fraudulent, and it may even lead to a lifetime bar from any immigration benefits in the future. So if this is the situation in your case, where the beneficiary is outside the United States, instead of applying for adjustment of status in the United States, then the process would require consular processing. Now, if the person is outside the United States and can enter on a dual intent visa, such as an H-1B visa or an L-1 visa, and once the person enters, then they can adjust status just fine. And again, let me explain. Adjustment of status is where you're changing your current status in the United States to that of a permanent resident, and consular processing is where you actually go to a U.S. consulate or embassy outside the United States and ask for an immigrant visa because a petition had been filed for you. Now also note, if the beneficiary did enter the United States on a visitor visa, which they have used several times in the past, it still might be safe to apply for adjustment of status. Each case is unique, and if you just entered on a newly acquired visitor visa, it is risky to apply for adjustment of status. For further clarification and assessment of such cases, we highly recommend that you consult with an experienced immigration attorney. Question number 4. Did the beneficiary enter the United States legally in any status other than a C-1D crew member, fiancé visa, other than that of the petitioners, or on the visa waiver program? If the beneficiary did not enter with legal did not enter with legal inspection or entered on a C1D as a C1D crew member, then they may not adjust status. Also note, if the beneficiary entered without legal inspection and has remained in the U.S. for over 6 months, then as soon as they leave, they may trigger a 3-year bar of inadmissibility, and if they leave after 12 months of unlawful presence, they can trigger a 10-year bar of inadmissibility, meaning that they would only be allowed to return to the United States after they've spent 10 years outside, unless they qualify for an inadmissibility waiver, which can be very difficult to obtain. Note that as long as the beneficiary entered the United States legally, even if they overstayed their visa for several years, they should still be allowed to adjust status on the basis of an immediate relative petition. So what about the fiancé visa? If you entered on a fiancé visa based on the person who sponsored you, you can adjust status if it's based on marriage to the person who filed the fiancé visa petition for you. But if you entered on a fiancé visa and then some other person petitions for you, you cannot adjust status on that basis. And of course, finally, there's the visa waiver program. Now, there are some exceptions, and it is possible to adjust status on the visa waiver program, but it's a complicated situation. It depends on what state you're located in, and the way these are treated depends on the way the federal circuit court treats these particular situations. So it's a complicated issue, and it requires a professional assessment if you're trying to adjust status as a visa waiver program entrant. And in general, we highly recommend that you do not adjust status if you've entered on a visa waiver program, on the visa waiver program. All right, so if you've answered yes to all of the above questions, and assuming you have no grounds of inadmissibility, such as 2-year residency based on J1 status or a criminal record, you should be eligible to file a criminal record that leads to inadmissibility. Not all crimes make you inadmissible, by the way. If that's the case, you should be eligible to file for an immediate relative petition for your family member, and they may adjust status. If you answered yes to only questions 1 and 2, then you may sponsor the relative, but your relative would have to apply for an immigrant visa at the consulate or the embassy abroad. This concludes the assessment. If you concluded that you qualify and you wish to prepare such an application, we recommend that you purchase our do-it-yourself toolkit. One of our toolkits is specifically tailored for adjustment of status, and the other toolkit is specifically tailored for consular processing, where it goes to the National Visa Center before it goes to the consulate for consular processing. And since our toolkit, since our guide is an audio-visual guide where we include and direct you to all of the required materials to prepare your application, you'll never miss a step or be confused. We are confident that you will find our kits to be the easiest to follow and most effective kits available on the market. However, if you are still unaware as to whether you may qualify and you have more questions, then we highly recommend that you arrange a consultation with an immigration attorney by calling the phone number listed below.